Good morning and welcome back to the BLC box. My name is Ruairi O'Neill, and this morning I'm joined by Dr. Anton Van Dellen, who is a London barrister at Fraser Chambers. Now, I don't need to give Anton any long introduction because our viewers will recognize him from an earlier BLC box. And I'm here, I'm in the same shirt that I was wearing the last time I spoke to Anton, and it would appear that Anton is also wearing the same shirt. So we could be forgiven for thinking that this is the same recording, except that the background in Anton's screen is different. It's a different part of the window from what I can see. So Anton, thanks very much for joining us this morning.
Thank you, Rory, from a slightly overcast London, but good to see you.
So this morning, we are going to be talking about a Supreme Court judgment that you've been involved in, and the judgment was delivered on Wednesday, the 3rd of June, in the case of Serafin and Malkiewicz. So this must have been a pretty high-profile judgment to warrant our editorial team inviting you back for an unprecedented second interview. So Anton, can you give us a brief overview? What was this case about?
Well, this was a fascinating case, Rory. Malkiewicz were the publishers of a Polish community newspaper published in England by the name of Nowy Czas. And they published matters of interest to the very large Polish community in England. And they published an article about a Mr. Jan Serafin. And in that, they alleged that Mr. Serafin was somebody who was an undischarged bankrupt, whose modus operandi was to defraud vulnerable women of their savings, and also somebody who was effectively a serial liar and cheat. So those were the allegations that were made in the newspaper. And what Mr. Serafin then did, understandably very upset by this article, was to bring proceedings for defamation in the High Court in England. And that hearing was heard before Mr. Justice J. So by way of background, for those not familiar with the law of defamation, it's if somebody's reputation has been damaged in the eyes of right-minded members of the public about something written or said about them, they can then sue for damages to their reputation. So in a modern context, that sounds very much like an Article 8 right. Its reputation is recognized as part of what's broadly construed as being an Article 8 right, the right of an individual to their personal integrity, that integrity including their reputation. So the case came on before Mr. Justice J in late 2017. The defendant publishers were represented by Tony Metzer QC, so a Silk, senior advocate at the Bar of England and Wales, and Mr. Serafin appeared as a litigant in person, although it appeared that he was having some legal help in the background behind the scenes. And he duly lost. The judge found that the publisher defendants could rely on a public interest defense, that it was in the public interest that this article be published. And Mr. Serafin then appealed to the Court of Appeal on two main grounds. The first ground was that Mr. Justice J had run the trial unfairly and had basically been horrible to Mr. Serafin during the trial and had stopped him asking questions and had cross-examined him, a judge cross-examining Mr. Serafin rather than Mr. Metzer QC cross-examining Mr. Serafin when Mr. Serafin was giving evidence. And the second ground of appeal was on the public interest defense, that the defendant publishers shouldn't have been allowed to use the public interest defense. The Court of Appeal found for the claimant, Mr. Serafin, who then became the appellant, on both grounds. They found that the trial had been unfair and that the defendant publishers couldn't use the public interest defense. I appeared for the defendant publishers together with Mr. Metzer QC in the Court of Appeal. And then the defendant publishers appealed to the Supreme Court, again on the same two grounds, namely that the trial had been run fairly and on the public interest defense. And what the Supreme Court found was basically that the trial had been unfair. Mr. Justice J hadn't conducted it fairly, and they've sent it back for that reason, sent it back to the High Court for a retrial, where I'll be representing the defendant publishers. And but very interestingly, the Supreme Court strongly disagreed with the Court of Appeal about the public interest defense and reinterpreted the public interest defense. So we were joined, Mr. Metzer QC and I were joined in the Supreme Court by David Price QC. So the three of us represented, were the counsel who represented the defendant publishers, who by that stage were the appellants.
Okay, thanks for that brief, that introduction. I'm going to plead ignorance in this part. So I remember from university studies quite a while ago that the public interest defense was the Albert Reynolds and Times newspapers criteria, right? And that's now been changed. That's now Section 4 of the Defamation Act. What did the Supreme Court say about the interrelation between those two tests? Like which one is, or what is the current test for the public
well,
interest?
it's a really interesting part of the judgment to read, because the lead judgment, or the only judgment, is given by Lord Wilson. The other four judges of the Supreme Court all agreed with Lord Wilson. What he did was track through the evolution of the public interest statutory defense in Section 4 of the Defamation Act 2013. So he started by reviewing the common law with the very well-known Reynolds test, which you've referred to from the case of Reynolds. And then explained why Parliament decided to move from that to the test set out in Section 4. And essentially, what Lord Wilson explained was the legislative purpose behind the Section 4 public interest defense. Effectively, Parliament had decided to recalibrate the balance between Article 10, freedom of expression, and Article 8, the protection of an individual's reputation. And effectively what Lord Wilson recognized was that Parliament said it needed to be moved closer to freedom of expression, and that needed to be strengthened. Article 10 needed to be strengthened. And so the new Section 4 public interest defense had to be interpreted through that lens in that way. So the old approach of viewing the 10 Reynolds factors as a checklist that a judge would laboriously work their way through is expressly not the approach. And Lord Wilson made that very, very clear. So a judge, we still have an echo of the Reynolds test, that those are still factors that the judge is may take into account if they wish to do so, but it absolutely shouldn't be treated as a checklist. And what the judges effectively said is, and I'll read out the Section 4 defense, and apologies that I'm just reading it out, but that's effectively what was done in the Supreme Court. So it's a defense to an action for defamation for the defendant to show, A, the statement complained of was or formed part of a statement on a matter of public interest, and notice it's on a matter of public interest, not in the public interest. So the statement needs to be on a matter of public interest. And B, the defendant reasonably believed that publishing the statement complained of was in the public interest. So the key words there are the defendant reasonably believed. And what Lord Wilson recognized is that that test meant that the reasonable belief meant there was an increased focus on the subjective belief of that particular journalist in the circumstances of that case at the time that it was published. The objective part of the test is the judge then effectively asks, after making effectively a finding of fact as to the journalist's subjective belief, was that belief a reasonable one to hold? And one of the things that can be taken into account there is, did the journalist check with the subject of the article or give them an opportunity to comment on the article? And that was one of the points in dispute in Serafin and Malkiewicz, is that the journalists didn't, it's common ground, the journalists didn't check with Serafin before they published the article. And they've got a number of explanations for that. But that was part of the reason why this was so bitterly fought over, is effectively what the Court of Appeal said is, well, that's a Reynolds factor, which is the checking, the verifying, is a requirement for the defense. And what Lord Wilson in the Supreme Court appears to be saying is, no, it's not a requirement of the defense. It's certainly something which appears can be taken into account. So we have an echo of the old common law test, the Reynolds factors, but if used through the prism of the statutory language. And the final bit of the test is the Parliament said, subject to subsections 3 and 4, in determining whether the defendant has shown the matters mentioned in subsection 1, the court must have regard to all the circumstances of the case. And that phrase, have regard to all the circumstances of the case, was added as the bill passed its way through Parliament, and was effectively, it's another signal from Parliament to the judge deciding whether this was a publication on a matter of public interest, to increase flexibility, to take into account all the circumstances of the case. Again, it's a signal that the judge is not confined to the 10 Reynolds factors. There are other factors that the judge can take into account as well. So the fundamental point is in that tension between freedom of press, Article 10, the right of the individual, Article 8, and their reputation. It's strengthening freedom of the press. And that's very important, obviously, from a democratic point of view, that newspapers that are published, for example, in the Polish community, have that freedom of press.
And coming back to that one point that you said was quite contentious about the failure of the journalist to check with the subject of the article in advance of publication, like following what the Supreme Court has said about that, would that be terminal or detrimental to their defense, failing to give the right to reply in advance of publication?
Certainly from reading what Lord Wilson has said, no, because he said that it's not a requirement, whereas reading what the Court of Appeal had said, which the Supreme Court expressly disavowed, that would have been effectively would have been fatal to their defense. And that's why on the facts of this case, that was a particularly important distinction to draw. But it is a very clear steer to judges applying the public interest defense that as to how they should approach it. So what's very interesting about this is the way Lord Wilson has not only looked at the language of the Act, but how the language changed as the bill passed through Parliament, and what was said in Parliament in Hansard about the Act as well. So it's a classic public law approach, how to construe a piece of statute, and then you map that onto the particular facts of the case to say, in the circumstances, in all the circumstances of our particular case, whichever case it is, we then apply what Lord Wilson has said about this public interest defense to those facts. So I think it's a very important judgment that is going to be cited effectively in most media defamation cases, if not all.
Okay, wow. So I just have two more questions on that point, and then we can come back to the fairness issue. So from the perspective of publications, how do you think that will look in the future when publications editors are considering whether to publish an article, whether there's a risk that they will be subject to a future defamation claim, whether they will feel more strengthened by the Supreme Court judgment to go ahead with the publication because the test provides greater protection for publishers? On one side, do you think that's what's going to happen? And on the other side, from the future potential defamation claimants perspective, do you think the Supreme Court judgment is going to result in claimants being given advice at the pre-trial stage that they should simply not proceed with a claim against a publisher because there's a very good chance that they won't be successful?
Well, I'm not a professional journalist. I'm not even an unprofessional journalist. So it's very difficult for me to imagine what factors are taken into account by a journalist when they decide to publish. But in terms of whether, at a broad brush level, whether this judgment has a chilling effect on journalists, I think the answer to that is absolutely not. It has the opposite effect. It means that the public interest defense is a more powerful defense for journalists. So if a journalist is mindful of a potential defamation action, this can give some comfort to them that actually this is following the handing down of this judgment on Wednesday. This is a more powerful defense or more useful defense to them than would otherwise be the case. Rory, you're absolutely right. That cuts the other way when claimants are deciding to sue. They will inevitably be given advice saying, even though you consider you may have a strong claim, you need to be aware of this judgment. You need to be aware of this potential defense. And this is an absolute defense. If they are successful on this defense, you will lose and you will pay their costs. And I think that's significant for not only claimants bringing a claim, but also lawyers when deciding whether to act for a claimant on a conditional fee agreement, a no-win, no fee. It may well mean that lawyers are more reluctant to act on a conditional fee agreement because of the increased risk that the claimant will lose. It may be more difficult if litigation funding is sought, and there are other problems with litigation funding and defamation claims because the damages are often quite small, but it may well have an overall effect of reducing the number of claims in defamation being brought to the High Court. And it's the usual law of unintended consequences. You know, what the Supreme Court is doing is looking at the public interest defense and interpreting it. But does this mean that it will be more difficult to bring a defamation claim? Absolutely, yes.
Okay, wow, that's really, I believe that is going to be very interesting for our viewers to see how that approach is being taken by the judiciary in England and Wales with regards to defamation. So I just want to ask you a couple of questions about the second ground for ordering the retrial by the Supreme Court, the fairness aspect. So what I really liked about the judgment when I read it was that the Supreme Court added in an annex all of the interventions by Justice Jay, which led to the finding that this was unfair. And I think this issue will be really interesting for our viewers and our students who are used to the continental legal system, where you have a judge that is very interventionist, that will be the one who will do the cross-examination, who will read this and think that this is quite interesting, that the Supreme Court is essentially telling off a judge for being interventionist and in a bad way. So what was that all about? So like, what was the issue there, and how did the Supreme Court deal with it? If you wouldn't mind explaining to us.
Well, it comes back to what I mentioned when I went through the facts, which was that Mr. Serafin was there as a litigant in person before Mr. Justice Day. And Ruairi, again, you're absolutely right. There is a fundamental difference between the English adversarial system and a continental investigative or inquisitorial system. So under the English system, the parties each put up their fight, descend into the arena, take up cudgels against each other. The judge remains aloof above the fray and rules as to points of procedure, make sure that the proceedings are fair, and then at the end gives findings of fact. In a criminal case, the jury comes back with a guilty or not guilty verdict and makes rulings of law and ultimately decides who wins in a civil case. There are a few exceptions to that in the English system. One is the coroner's jurisdiction, which is an investigative jurisdiction, and the judge starts off asking the questions, much more akin to a continental system, although ironically the coroner jurisdiction goes back 800 plus years. Another difference would be where the courts English courts are exercising a regulatory or disciplinary function. So if are unmeritorious claims being made for judicial review in an immigration context, the court, the upper tribunal, the high court will convene what's known as a Hamid court and question the lawyers and then potentially refer them to their regulator. And the other area where this has been chipped away is with expert witnesses. If they give evidence concurrently at the same time in a process known as hot tubbing, the judge will start off by asking the questions. But the fact that I'm giving
Great
such
name of the procedure, by the way.
Hot tubbing, yeah, it sounds far more interesting and exciting than it actually is. But the fact that these are such unusual examples shows that the English system is primarily an adversarial system. Now, over time, that has changed, and a more modern judicial approach has been to become more investigative, where the judges ask questions, and that tension has arisen increasingly in the English courts. What the Supreme Court has said basically is if the judge starts cross-examining a witness, particularly during examination in chief, or if the judge stops a party asking questions and putting their case to a witness, that renders a trial unfair. And those are two slightly different things. The first is a style of questioning, which in Europe would be recognized as investigative judicial questioning. That's been criticized by the Supreme Court. The other one, stopping a party asking questions or putting their case, would be something even in the English adversarial system would be recognized as being a problem. But the Supreme Court went further. They also said the judge was quite rude and offensive to Mr. Serafin. Now that's interesting because if you think about it, just because a judge is rude doesn't necessarily mean that a judge is being unfair to a party. They can be brusque with the party. They can be dismissive of an argument that a party is running, but that doesn't automatically mean that the trial is unfair. So when you read, and you've referred to the excerpts recited or annexed to the judgment, the excerpts all fall into one of those three categories. Some of the criticism of the Supreme Court since the judgment was handed down on Wednesday has been that the Supreme Court hasn't actually given guidance as to what would be unfair judicial behavior in a trial. So we can see the examples they've given. We can see they've sent it back to the High Court for a retrial. But actually, if you were to say, what are the points of principle? I've attempted to give 3 points of principle, 3 areas in which the criticisms lie. But actually, that's not in the judgment. It's not laid down as these are the clear principles. These are the clear facts and factors that would automatically render trial unfair. And again, we come back to the law of unintended consequences. By definition, 50% of court users will leave the courtroom disgruntled because there's one winner and one loser. So of those 50% disgruntled, what this judgment is effectively doing, inviting them to go back, pore over the transcript in a very forensic way, in the way that Lord Wilson did, and run an appeal saying, oh, look here, the judge said, we said something to me in an irritable way or dismissive way or rude way, or he stopped me asking this question. Judges stop parties asking questions all the time because the question is irrelevant or it's not in the pleadings. And so I think we're going to have a lot of court time taken up with these sort of appeals, with parties going, oh, we're the same as that. And the genie may well be let out of the bottle. I personally think there was an opportunity missed for the Supreme Court to say, well, yes, Mr. Justice J may have been unfair, but modern English judicial procedure or conduct is in fact a more blended mix of adversarial and investigative, and judges can ask questions as they do on the continent.
Do you think it was you say it was a missed opportunity, but do you think it was intentional, that the Supreme Court intended not to provide clear guidelines for trial judges?
Well, obviously, I was sat through on the
maybe
second
it's Brexit
row.
related, like everything else.
Yes, I mean, it's very difficult to know what went through their mind. There was you know, the hearing can be watched online on the Supreme Court website. Certainly in terms of the way the appellants, the publisher defendants, put the case on unfair trial.
In a more advanced video blog, I would point to the link that people can activate. And
excellent. Thank you, Rory. So I mean, you can watch to see the submissions that were made on unfair trial. It's about an hour for the claimants, just before. So it was the tail end of, sorry, not for the claimants, for the appellants. So the appellants, we started with our submissions on the public interest defense and then went on to unfair trial. So if you're particularly interested in unfair trial, you can watch the submissions at the tail end, about the last hour. Mr. Metzer QC made those submissions. And then that was followed by the respondents. Their submissions, they front-loaded their submissions on unfair trial. You can watch the interventions from the Supreme Court, but there wasn't, certainly my recollection is, there wasn't an indication that they were going to be given, going to be handing down a set of principles that people could apply, and a matrix that people could apply and to their trial to work out, has this trial been unfair or not. And one of the difficulties with the process of the excerpts is, as was recognized by Lord Wilson, there are large tracts of the trial where in fact there weren't any problems, and cross-examination proceeded smoothly, examination in chief proceeded smoothly. Mr. Justice J referred to Mr. Serafin's closing submissions as a tour de force, which didn't suggest, and we, for the appellants, certainly said to the Supreme Court, didn't suggest that Mr. Serafin had effectively been cowed in making his closing submissions. But you will have seen what Lord Wilson said. Effectively, if the proceedings were unfair, it can't be salvaged by a very well-crafted judgment by the trial judge. They are, in effect, unfair. But I think we are going to see a process where litigants will get transcripts and will fill it out excerpts and will run appeals on that basis. And a lot of judicial time and court time is going to be taken up with wholly unmeritorious appeals run on that basis.
Well, that's all we have time for, I'm afraid. But I just want to say thank you very, very much, Anton, for coming back and giving us that very current overview. And I think our students will find it really interesting, especially anyone who's interested in defamation law, a comparative approach to defamation and the public interest defense, and also the difference in the role of the judge in a trial, which is one of the biggest differences in procedure between our legal system and continental European legal systems, and how the Supreme Court has approached or failed to deal with those modern developments. But thanks once again for joining us. And yeah, well, have a lovely day.
Thank you, and to everyone in Poland as well. Thank you very much.